Charged with fraudulent use or possession of identifying information less than 5 items. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000. ER 000686, State versus Summer Muniz. Could I have parties announced?
State. James Seeloff for the defense.
And are you Ms. Muniz? Counsel, have you received all discovery? Did you review it with your client?
Yes, I have, and I have.
Court will find that the state is in compliance with discovery. Ms. Muniz, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, on all the cases.
Thank you. State, are you proceeding on the indictment as presented?
Yeah, Judge.
Ms. Muniz, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
By indictment, you're charged with fraudulent use or possession of identifying information less than 5 items. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea, gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she was.
Ms. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported and denied re-entry. Did you understand?
Yes, ma'am.
And also denied naturalization. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she was.
Ms. Muniz, has anyone threatened you, coerced you, or placed you in fear to get you to? I'm sorry, I already
You're
done
doing it
that.
twice.
I'm doing it twice.
I like your voice, so I just
You
listen.
just went along with it. Okay.
Yes, ma'am.
Did you review the plea? The court will find that the defendant has knowingly and voluntarily waived her right to jury trial. That's what happens when I'm trying to multitask. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
All right. So everything, the plea bargain agreement that I previously stated, do you understand that to be your plea?
Yes, ma'am.
Defense,
Yes.
state.
It is, Judge.
And did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
All right. You're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No motions, Your Honor.
Outside the agreement, the state is asking that you have no contact with the complainant and no contact with Fox Rental Car. Did you understand that?
Yes, ma'am.
That's a recommendation from the state, and the court does not have to follow that recommendation. Did you understand?
Yes, ma'am.
Then to the offense, how do you plea? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Judge, we got for state exam number 1 and all attached.
No objection.
All right. Did you review the waiver and stipulations with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
So,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we are.
Anything you wish to say on behalf of your client?
We have worked out a pretty nice deal with the prosecutor on this, and asked the court to follow. She's 29 years old and needs another break, one break. And she's going to go to the TDC for 6 years. So that's what she's going to learn.
All right, the court is going to sentence you to 2 years in the state jail facility, give you credit for any time served, There's a $1,200 fine. Time and money will run concurrent. This will run concurrent with 2022 CR 2906. And there's to be no contact with Fox Rent-A-Car. Do you understand?
Yes, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it and sign it?
yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Next, we're proceeding in 2023 CR 2906. Did you review the document entitled Motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Summer Muniz who was placed on deferred adjudication in 2023 CR 2906 for the offense of tampering with a government record on May 15, 2023 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state, you may proceed.
Yes, Judge. Well, you will be proceeding on violation of Division Number 1, specifically the on or about 3rd day of January 2026 from Berry County, Texas. The defendant, Summer Marie Muniz, committed the offense of fraud in violation of Division Number 1.
How do you plead to that? True or not true?
True.
State,
The judge will be waiving the remainder of the allegations.
any objections?
No objection, Your Honor. That's our understanding.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge. Following the defendant's repeated violations of the rules of safety and being kicked out of felony drug court, we don't believe she's recommended for probation. The agreed amount is 6 years to do in the Texas Department of Corrections.
Yes, and we're asking for the court to give her full credit for time served, including her safe P time. Thank you. That's our understanding.
All right, are you asking the court to follow the agreement that you reached with the state? Are you waiving your right to appeal? All right, so here's the question for the court. Was safe P successfully completed or no?
I don't believe it was.
Was it?
Yes, it was
It was?
successfully discharged. I have my certificates. I know they didn't get an extension.
All right, this is what the court is going to do. The court will find you guilty, revoke, sentence you to 6 years in the prison, give you credit for any time served, and they'll make a determination on whether or not you successfully completed inpatient treatment or not. But the court will give you credit for any successful completion of inpatient treatment. Legally, that's required. The court will recommend the therapeutic community. Is there anything else with regards to sentencing?
Not from the state, Judge.
Nothing, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, if you don't change the way things are going for you, only two things going to end up happening. Either you're going to end up spending the rest of your life in prison, or the last time you use may be the last time you use. How are you? How old are you? All right, so you have a lot of your life in front of you. But, I have a friend who went through what you're going through. They're doing great now, but now guess what? They have to take extra care of their body because they said they just put their body through the ringer by doing all of these things because there's a lot of health issues that comes with that. And so you're going to have to get it together. When you're released from prison, if you can't find a place to help you on your road to sobriety, come back here. If I'm still here, I'll help you, okay? All right, good luck to you.
Thank you, Judge.
This courtroom proceeding centers on Summer Muniz, a 29-year-old defendant charged with fraudulent use or possession of identifying information, a state jail felony in Texas. The punishment range includes 180 days to 2 years in a state jail facility and fines up to $10,000. Muniz entered a guilty plea after being fully admonished of her rights, including her right to a jury trial, her right to confront witnesses, and her right to remain silent. Judge Stephanie Boyd confirmed that the plea was voluntary, informed, and supported by sufficient evidence. Initially, the case appeared routine. The court accepted the plea bargain and sentenced Muniz to 2 years in a state jail facility with credit for time served and a monetary fine. However, the legal stakes escalated when the court immediately addressed a separate but related matter, a prior deferred adjudication for tampering with a government record. Muniz admitted to violating the conditions of her probation by committing a new fraud offense, triggering a motion to revoke. This is where the case took a decisive turn. Because the violation was proven true, the court gained full authority to revoke community supervision and impose a prison sentence of up to 10 years. The prosecution emphasized Muniz's repeated failures, including her removal from felony drug court, arguing she was no longer a candidate for probation. An agreed recommendation of 6 years in the Texas Department of Criminal Justice followed. Judge Boyd accepted the agreement, formally revoking probation and sentencing Muniz to 6 years in prison, with credit for time served and consideration for completed treatment programs as required by law. The decision underscores a core principle of the justice system. Deferred adjudication is an opportunity, not a guarantee. When a defendant repeatedly violates court-ordered conditions, leniency gives way to accountability. What makes this case resonate is not just the sentence, but what followed. Judge Boyd stepped beyond procedural formalities to address Muniz directly. She delivered a stark warning about the trajectory of continued criminal behavior and addiction, prison or death, while also offering something rare in a sentencing courtroom: conditional compassion. Her message made clear that the justice system can impose consequences while still recognizing the human cost of repeated failure.